Thank you very much, Joseph. It's an absolute delight to be here in Parliament again, particularly in this absolutely splendid room, the Jubilee Room. And for anyone who gets bored, just check out the stained glass in the ceiling. It's magnificent. Now, the first thing to say about the Crown in New South Wales is that we actually don't have one in the literal sense. We have a state flag, a state governor, we have a state government house that looks distinctly like a castle with south-facing rooms that are befitting of a building that seeks to emulate the Northern Hemisphere. And we, of course, have a state flower, the waratah. We have a state bird, the kookaburra, a state animal. Anyone know what the state animal yet is? Platypus, indeed, although I think we should be calling it the state monotreme to be more precise. And we have a state fish, and I made that. Now, what happened was I was working in the New South Wales Cabinet Office at the time, and the Premier rang me and said, "How do you make a state fish?" And I thought that was a joke, and I said, "I don't know, how do you make a state fish?" And he said, "No, I actually want to make a state fish." And I thought to myself, well, goodness me, they don't actually teach you in law school how you exercise the executive power to make a state fish. So I had a sudden inspiration and I said, we will get the governor to proclaim and issue a proclamation that this fish is the state fish. And indeed we did. Now, I should add, for those of you who now know about state emblems, that this was before there was legislation on state emblems and symbols, so we could just do it by way of a proclamation. And the state fish that the Premier wanted was called the blue groper. And I thought to myself, well, that's a game choice for a politician, because there's probably more blue gropers around this building than there are in the ocean. But anyway, after my great success on the front of the state fish, I understand that my successors in office were plagued by a fight amongst community groups who wanted to choose a state insect. Apparently there was a particular ant and a particular bee, the various groups were so passionate about it that we do not have a state insect as a consequence, but we do have a state fossil, which of course opens itself up to many jokes, particularly as the Legislative Council over yonder was in earlier times described as the House of Fossils. But for all of that, we do not have a bejewelled fancy hat, like so, that we could declare to be the state crown. Now, in contrast, Scotland does indeed have its own crown jewels. They're known as the Honours of Scotland. And they're older than the British crown jewels because, of course, Oliver Cromwell didn't manage to get his hands on them. They managed to hide them from him. He did try quite hard, and some very game woman smuggled them out of a castle in her clothing. But anyway, the Honours of Scotland, the crown jewels there, were displayed in Parliament in Scotland when it still sat. From the 16th century, royal assent to bills was signified when a bill in the Scottish Parliament, the final printed version, was touched with the royal sceptre. So there you go. You touched your bill on the sceptre, and that's what gave you royal assent. Now, in the absence of a physical crown, or indeed a sceptre in New South Wales, what does the crown mean in the context of New South Wales, and what power does it hold? It essentially means executive government of the state and the exercise of executive power. These days, that power is exercised in substantive terms by ministers under the doctrine of responsible government, and it's usually conferred upon them by statute. But in this lecture, I'm going to focus on the governor's powers and how they have changed over time. After the British set up their colony in New South Wales, executive power was exercised by the governor as a representative of the monarch in accordance with the Governor's Commission, royal instructions and letters patent. Now, the early governors, as Joseph said, had significant discretion in exercising their powers, and that included the power to make laws, the power to grant property, and the power to grant pardons, which was particularly important in a penal colony. But as time passed, the settlers demanded the same rights and protections as they had back home in the United Kingdom. And the governor began to be advised by a legislative council with respect to the passage of legislation. So we're currently celebrating the bicentenary of that establishment of the Legislative Council in the period 1823 to 1824. So 1823, when first the legislation was enacted to allow for this, and 1824 when it first sat. In those days, the members of the Legislative Council were appointed by the governor, not elected, and the governor had the sole right to lay bills before the Legislative Council, but still had to act on the advice of the Legislative Council in passing bills except in cases of urgency. In 1825, the Executive Council was created in accordance with royal instructions. The governor had to consult it and act on its advice except for urgent matters or where the interests of the British Crown would be adversely affected. The governor was, of course, a representative of the monarch and the British government. If the governor acted contrary to the wishes of the Executive Council, the governor then had to give reasons to the British Secretary of State for the colonies. Now, from these beginnings, there was a fairly swift progression towards the adoption of representative government, with a majority of the Legislative Council being elected in 1843, and finally responsible government in 1855. From then, the conventions of the Westminster system of responsible government were largely adopted in New South Wales. That meant that the governor acted upon the advice of his, and I should say they were all hims back in those days, the advice of his responsible ministers, and of course the Chief Minister, who we now call the Premier, was appointed by the governor based upon convention that he would hold the confidence of the lower house. Now, this transition from a governor having essentially quite large powers and great discretion to a system of responsible government was challenging, as was shown by an incident about the public seal of New South Wales. When Governor Phillip was first given his commission, before the First Fleet left to sail for Australia, it authorised him to keep and use the public seal of the colony as an expression of his authority. But the seal itself didn't arrive in Australia until 1791. Now, the seal is used as a formal symbol of the exercise of executive power, and it's used for sealing particularly important official documents, such as viceregal appointments, the commissions of judges, letters patents, royal commissions, those sorts of things. And a new seal is made in relation to each monarch, with the previous seal then being defaced, which I think is a rather marvellous term for it. Back in 1861, shortly after the commencement of responsible government, there was a tussle over the use of the seal, which reflected the inherent conflict of interest faced by the governor. On the one hand, the governor was advised by his responsible ministers in New South Wales, and by convention was bound to act upon that advice. But on the other hand, the governor was a representative of the monarch and was subject to instructions by the British government to act in their interests. Now, the case concerned a convict who had done well in New South Wales and then returned quite wealthy to Britain. He married there and he had a child, but he also kept a mistress with whom he had another 2 children. Now, there was a disagreement with the mistress and he killed her by poisoning her, and he was convicted of murder and he was hanged. So the dispute concerned his property. His British property was returned to the widow and the legitimate child, but part of his New South Wales property had been improperly sold. Now, after years of legal skirmishes about this, the British government instructed the Governor of New South Wales, Sir William Denison, to make a grant of the property to the widow. For it to be valid, he had to affix the Great Seal to the grant. But the seal was physically held by the government, and it objected to the Governor making a land grant except without its advice. It said you could only grant land on ministerial advice. Now, the Governor wrote to the Premier insisting that he deliver the seal over to the Governor's secretary. He argued that the Governor's commission said that he had sole authority to attach the seal. The Attorney-General argued that that now had to be read in the context of responsible government, so that the seal could only be affixed upon the advice of ministers. The Governor, however, was adamant that the seal be returned to him, so the Premier, William Cowper, gave up the seal, but in handing it over, he handed it with his letter of resignation of the government. The Governor sealed the relevant document and then sent the seal back to the Premier with a refusal to accept his resignation. Cowper then continued in office, and the Governor then set sail for Madras, which was his next posting anyway, so he was out of the country, while Parliament was debating his censure as he sailed away. Now, this struggle over the public seal of New South Wales in 1861 is a good illustration of how changes in convention can affect the powers of the Governor, and that there's also quite a significant gap between the text of the law and the operation of convention. It also shows the difficulty faced by a governor who effectively had three masters: the monarch, the British government, and their local responsible ministers. Other conflicts later arose when governors refused to accept advice to swamp the Legislative Council next door with appointees from whichever party was in government. This became particularly acute during the period of the Lang government. As the powers of the British government began to wane in Australia, the conventions also began to change, particularly during the time of the imperial conferences of the 1920s up to 1930. Now, the other reason for mentioning the public seal of the state is the growth of the sovereign citizen movement in Australia and the types of legal challenges that are brought by people who claim that some small technicality, such as a seal or an oath, or even where on the page there's a royal signature, that's a big one that's been going around recently, signed on the top, not the bottom, must be unlawful. So these sorts of claims are made that somehow some small technicality causes all law from a certain point in time to be invalid, so the relevant person doesn't have to pay their council rates or pay their taxes, or can't be made bankrupt, or can't be convicted of a driving offence. Now, a very early version of such a claim was made in 1953 in the case of Saffron and Delaney. An order had been made by a judge declaring that an establishment that was owned by Abe Saffron, who was often euphemistically described by the media as a colourful Sydney identity, that it was a disorderly house. Saffron claimed that, according to legislation, the Supreme Court judges had to be appointed under the Great Seal, whereas the judges had actually been appointed under the Public Seal of the state of New South Wales. Now, the Supreme Court was singularly unimpressed by this argument. Chief Justice Street, in a judgment that's applicable to many of the claims brought by sovereign citizens these days, claimed that the outcome sought by Saffron, which was effectively that all the judges were invalidly appointed, would be so startling and the consequences would be so monstrous that no court would give effect to the argument unless constrained by language from which there was no escape. His Honour held that it was plain that what was required was the use of the seal which the Governor for the time being authorised to be used on the Sovereign's behalf in New South Wales as the highest and most formal symbol for making manifest the royal will. That symbol was the seal of the state, as currently approved and in use for that purpose, whether it be described as the public seal or the Great Seal was of no moment. And this is now confirmed, by the way, in Section 17 of the Interpretation Act, in case anybody wants to bring that point again. The point here, however, is that no court is going to rely on these silly technicalities to strike down laws or to invalidate orders by judges. It's simply not going to happen. In another challenge in 1994, a convicted person argued that his sentence was invalid because the governor had not personally affixed the seal to the sentencing judge's commission. Again, the court rejected this argument, pointing out that it was difficult to see why the task of actually affixing the seal, and by the way, if anyone's ever seen it, it's this huge, big metal contraption that you wind down. It's actually quite an interesting thing to do. But anyway, this is not done by the governor personally, okay? And they pointed out that it was difficult to see why the task of affixing a seal was one that only the governor could do. The court held that it was an entirely sensible interpretation that those functions be performed under the governor's authority. So even though Section 9, capital H of the New South Wales Constitution says that the governor shall provide, keep and use the public seal of the state, the contraption for sealing the documents can and does sit in the Cabinet Office, and the seal can be affixed there as long as it's being done under the authority of the governor, following his or her signature on the relevant Executive Council minute and the judge's commission. Now, for those worried that the public seal of the state will no longer work because we've had a change of monarch, that's not the case, because historically it often took a long time for the news of the death of the monarch to reach Australia, and even longer for a new seal to be engraved and delivered to Australia. It's always been the case that the seal of the previous monarch can continue to be validly used until a new seal is provided. At that point, once a new seal is provided, the old seal is defaced. Now, I'm told by the Cabinet Office that the process for creating that new seal for King Charles III is underway. Once the new design is approved by the Premier and the Governor, it will be manufactured on the Governor's behalf, consistent with Section 9H of the Constitution. Another very old power of the Governor is the prerogative of mercy. Now, for those who watched the coronation of King Charles III, I figure quite a lot of you did, not only was he crowned with the crown of St. Edward, and then later wore the imperial state crown, there were also various other forms of regalia presented to him, including the curtana, which is a sword known as a sword of mercy because the end of the sword is blunt, okay, so no one's going to run you through with it. And also the scepters. You might have seen him sitting there with the two scepters. Here's my little scepter. So the one of the scepters is described as, that's the scepter with the dove, is known as the rod of equity and mercy. And this is intended to indicate that the king's power is to be exercised according to law, tempered with mercy. This was particularly important in the early days of the colony of New South Wales. Penalties were extremely harsh, with the death penalty applying to a large range of offences, including property damage, such as cutting down trees, and there was a great need for the exercise of the prerogative to achieve some level of justice, fairness and mercy. The commissions of each of the governors conferred upon them full power to grant any offender a pardon or respite of execution of his or her sentence, subject to royal instructions. The instructions stated that with respect to death sentences, the governor had to consider the advice of the Executive Council on pardons and commutations, but then had to make a decision according to his own deliberate judgment whether the members of the Executive Council concur or not. Non-capital cases were dealt with by the governor personally without ministerial advice. Now, this led to significant conflict with ministers, particularly when the governor decided to mitigate the sentence of a rather notorious bushranger. The bushranger was Frank Gardner. Now, he'd been acquitted of the offence of wounding a police officer with intent to kill, but he was convicted of 2 non-capital offences. And he was sentenced to 32 years hard labour for those non-capital offences. And it was argued by some that the severity of the sentence showed that it was intended also to punish him for offences that he was suspected of committing, but which he had actually not been convicted of. Accordingly, there were petitions for his release after he had served 10 years of his sentence. Now, the matter was the subject of fierce debate in Parliament over 5 days, and a motion opposing Gardner's release was only defeated by the casting vote of the Speaker. The Governor considered petitions for and against releasing Gardner, and he also consulted the Chief Justice. But curiously, the government offered no advice to the Governor on the matter, although later the Colonial Secretary, effectively the Premier, Henry Parkes, claimed that he would have advised against the release. Yes, all done with the perspective of times afterwards. Anyway, the Governor ultimately did exercise the prerogative of mercy, releasing Gardner on condition that he leave the colony. In the ensuing ruckus, the government of Henry Parkes was actually defeated in February 1875 on a vote of confidence, and it was replaced by the Robertson government. The British government also became involved, with the Earl of Carnarvon criticising the Governor for not obtaining written ministerial advice before exercising the prerogative and for imposing the condition that Gardner leave the colony. Other places weren't terribly keen on having him, including, curiously, the United States, which complained. In May 1875, Lord Carnarvon instructed all Australian governors that they should not exercise the prerogative of mercy without having received formal advice from ministers. The letters patent of 1879 also provided that the governor shall not make it a condition of any pardon or remission of sentence that the offender shall leave the colony, except in relation to offences of a political nature, unaccompanied by another grave crime. Since then, a convention has developed that the governor would act upon ministerial advice in relation to the prerogative of mercy and the remission of sentences. The British government no longer has a role, obviously. The letters patent and the royal instructions since 1987 no longer exist, but the royal prerogative of mercy has been preserved. In the 1980s, there was a controversy when it was alleged that the Minister for Corrective Services, Rex Jackson, had accepted a bribe and conspired to achieve the early release of prisoners. Jackson was convicted and imprisoned. The government then changed its practice to ensure that it wasn't an individual minister who was issuing advice to the governor in relation to such matters, but in fact it now goes through Executive Council. And that's to ensure that there's more eyes and scrutiny on these sorts of things so that corruption cannot be involved. So in short, the governor has no personal discretion these days in relation to the prerogative of mercy. It's a matter for the government to advise the governor through the Executive Council on this matter after consideration of advice by the Attorney General. So what other powers does the governor have? Apart from the governor's constitutional and prerogative powers, most of the governor's powers are conferred by statute. They include powers to make regulations, to compulsorily acquire property, to make certain appointments. Section 14 of the Interpretation Act 1987 says that where the governor has been given a power by statute or another instrument, the reference to the governor means the governor with the advice of the Executive Council. So that means that most of the governor's powers are exercised upon the advice of ministers through the Executive Council, and the governor has no personal discretion. The governor, however, of course, cannot be required to breach the law. The law applies to everyone. That's what the rule of law means. So the Governor may request legal advice from the Attorney General or the Solicitor General to ensure that any actions that he or she is advised to take are legally valid. If advised that the action is valid, then the Governor would ordinarily act upon that advice, then leaving it to courts to decide later on upon the legal validity of the matter if it is later challenged. Does the Governor have any power or discretion at all these days? The answer is yes. Much of that power is what we call soft power, which involves the Governor querying matters that come before him or her, seeking legal advice about it and raising concerns. A wise Governor can influence governments to correct errors and can persuade them not to push constitutional boundaries. A Governor, through sharing their experience, raising different perspectives on an issue and pointing to risks, can sometimes persuade the government to take a different, more constitutionally secure course. And that's why it is important to choose as vice-regal officers people who have experience, good sense and gravitas to be able to exercise such influence for the public good, rather than just choosing someone who looks good in a hat. Some substantial hard powers do remain, including the reserve powers. They include the power to appoint the Premier and to dismiss the government. Those powers are governed by conventions and again do not involve personal discretion. A Governor cannot appoint or dismiss a Premier just because he or she likes or dislikes the Premier. The powers can only be exercised for constitutional purposes and in a manner that supports fundamental constitutional principles such as representative and responsible government and the rule of law. In New South Wales, the Governor's reserve powers have also been curtailed by the fixed-term Parliament provisions in the New South Wales Constitution. They limit the power of the Governor to dissolve Parliament, and that also has an impact if you're going to dismiss the government, because you do need to then have an election immediately afterwards for democratic reasons. The Governor may dissolve a Parliament early if a vote of no confidence is passed in the Legislative Assembly and various timing issues are met, or if the Legislative Assembly rejects an annual appropriation bill or fails to pass it before, quote, the time the Governor considers the appropriation is required. I have to say I was always a bit curious about that wording. I'm not quite sure how the Governor decides when the appropriation is required, but fortunately we've never had a crisis that helped us understand that. The Governor then has a discretion, if those circumstances arise, as to whether to dissolve the House early, because it says the Governor may do that, not that they must, or to appoint a new government without an election, sometimes known as a baton change, taking into account, and this is required by the Constitution, taking into account whether the Legislative Assembly has expressed confidence in an alternative government in which a named person would be Premier. So that's in section 24B6, if anyone wants to know. But there's also the mysterious section 24B5 of the New South Wales Constitution, which provides that the section does not prevent the Governor from dissolving the Legislative Assembly in other circumstances, despite any advice by the Premier or the Executive Council, if the Governor could do so in accordance with established constitutional conventions. So that leaves open potential discretion and presumably an awful lot of fighting and hopefully people reading my book about the reserve powers. But really, hopefully, we never get to those sorts of circumstances to see what would happen. The role of the Governor today is often described as a guardian of the Constitution. While the Governor has limited discretion, he or she still has an important constitutional role in three areas. First, there's an oversight role, checking that matters which come before the Governor are being dealt with properly and legally, identifying errors and requesting that they be fixed. This extra set of eyes and the level of formality that's involved provides greater scrutiny and is important to maintain the proper functioning of government. Second, the governor has that soft power of influence when a government is pushing against the constitutional guardrails. That influence can be profound, but it's rarely seen because it's most effective when it occurs behind closed doors. And this can leave the public blind to the governor's real significance in the constitutional system. And third, the governor does retain some reserve powers, but, as I said, they can only be exercised in limited circumstances and not as a matter of personal discretion. While governors are often implored to dismiss the government for one reason or another, in reality, this cannot happen except in an extremely narrow set of circumstances. Ultimately, it's the democratic role of the people to dismiss the government through elections. And that's the appropriate place in a democracy for the power to reside. Thank you.
Thank you. David Flynn. During COVID, we saw examples of massive regulatory changes by ministers, 2 ministers, for example, not going through the Executive Council. They didn't need to under the legislation. There was one which involved the closing down of the building industry for about 2 or 3 weeks. And this was done without explanation. Do you think that serious exercises of executive power should be vested in the governor and the governor only, not advised by the Executive Council? And do you think there should be some formality similar to legislation for such things? For example, at least an explanatory memorandum setting out the reasons for that.
Yep.
Thank you. And by the way, an excellent piece, if I may say so.
Thank you. Look, I do have sympathy for that position. I think the more formality, the better. It's funny, I often deal with other colleagues and they say things, well, why have the Executive Council? Isn't that just a duplication of cabinet? Why have both? And, it's ridiculous and get rid of these ancient formalities. But if you've ever worked in government, you know that actually formality is a really important thing. It's where the errors get picked up. It's where you make sure that things are done legally and appropriately. It saves you from all sorts of problems later on. And it does save you from corruption and dodginess and people doing things too quickly and doing them badly. So I am in favour of, what politicians often think of as red tape, etc., etc. Often that's there for really important reasons, and particularly constitutional reasons. So generally I agree with you, David. I think that too often these days legislation permits subordinate legislation to be made by ministers alone and not the governor. And that's been a trend in recent times. I think it's a bad trend from a democratic point of view. I mean, the whole Rex Jackson thing sort of showed that, if a singular minister is doing things, they can potentially do things inappropriately and etc. And it's much better for these things to go through various sets of eyes and go through the formality of the Executive Council. In relation to COVID, however, the one thing we do need to be aware of is that these sorts of decisions were made under legislation intended to deal with emergencies. And so emergency legislation often has within it far greater flexibility because you don't know in advance the nature of the emergency. So it might be the nature of the emergency is such that you can't hold an Executive Council meeting, etc., etc. And we did see problems with, parliaments being shut down and various things like that. So that's one of the reasons why emergency legislation has built within it much more flexibility for individual ministers to make decisions and make them really quickly and not go through the processes. I have some sympathy for that because you are legislating in advance for something when you don't know what it's going to be and you don't know whether the Parliament would be able to legislate and be able to sit to legislate to give extra flexibility if that was otherwise needed. So you've got to put the maximum flexibility in to begin with because you just don't know what you're facing. Having said that, one of the views I took throughout all of this is, okay, if your emergency is going to continue, it's not just a short emergency of 2 weeks or 3 weeks. If it's an emergency that's going to continue for months and months and months, then I think there needs to be a sort of a system where greater scrutiny comes back into this position. So, for example, at the Commonwealth level with their biosecurity legislation, all of that stuff put through, they were non-disallowable instruments, so Parliament had no ability to disallow them. That might be reasonable at the very beginning of an emergency where you don't want the uncertainty of whether this is going to be knocked over by Parliament in a week's time. I'm dealing with some kind of a massive emergency. But when it's 3 months or 6 months later, I think you do need to have, if the emergency is continuing that long, you need to bring back those kinds of democratic scrutiny functions. So could we do better than we did in COVID? Should there be ways of restoring some kinds of democratic scrutiny aspects, particularly if an emergency goes on a long time? I think yes, but I also have some sympathy for the fact that in enacting legislation to deal with emergencies, you do need to try and contemplate the unimaginable and to provide for it. And that does make things difficult. Anyway, sorry, a long answer. I'll let you find other people.
Anne. So we received 2 comparative questions, so I'll combine them together. Mm-hmm. How does the role of the governor in New South Wales compare to the roles and powers of governors in other states and the Governor-General?
Okay. Well, other states, pretty similar, but of course there are some differences. So, for example, strangely in South Australia, royal assent, for example, goes through Executive Council, whereas in New South Wales, royal assent is done individually by the governor, effectively fulfilling their role as part of the Parliament. So there are differences there. There are differences that also arise because of different state constitutions. So with New South Wales having that fixed-term Parliament, those provisions that limits the governor's discretion in a way, whereas the Tasmanian governor, for example, has more flexibility because they don't have the same restrictions. So on the whole, the roles are pretty similar, but there are constitutional differences between them. In relation to the Governor-General, again, there are a lot of similarities, and that's one of the reasons why state governors are used to be administrator of the Commonwealth when the Governor-General is unavailable, because the state governors pretty well know and understand the role and the ropes, whereas normal people probably wouldn't. Yes, again, no, it just depends on the terms of your constitution and, the relevant practices at whatever. They're probably slightly different at the Commonwealth level, but on the whole, relatively similar.
Thank you. Do you have any other questions in the room? Yes.
Thank you.
We'll go 1, and there was another gentleman at the back. We'll go 1 and 2.
There were sort of 2 things I wanted to ask. Is that all right if I do that? There were sort of 2 things I wanted to ask. One was just clarification that at the end of your speech, there were sort of 3 points you made in summation of the governor's role, and I missed the second one.
That was the soft power one. So if you go back to Badgett, it's that sort of notion of, counselling and warning and the like. Sometimes they add advise. But really it's just an ability to, when you're having a cup of tea with ministers after Executive Council, saying, well, do you really think that's a good idea? Here might be a problem. Or, before I sign this, I want some extra advice because I'm a bit worried about that. And those kinds of soft, gentle ways of pointing out problems do cause pause on the other end. So I used to be on the other end when I worked in Cabinet Office. I get a call from the Governor's secretary saying, we've looked at this and we think you might be doing it under the wrong act, or this compulsory acquisition won't work because of blah. And 9 times out of 10, they were right, and we fixed it because, mostly when stuff like that happens, it's not a conspiracy, it's just a mistake. And you're really grateful when someone picks it up. Sorry, that was more the first point, which was the scrutiny point. But the second point is they do get an opportunity to influence. Yep.
I suppose this is related to that. You did talk about the importance of governors sort of being legally sound, legally aware because of that sort of oversight role. Now, as I understand it, it's not as common now for governors to have a military background, but I believe David Hurley and Sir Peter Cosgrove both did, and they were recent governors. And I wonder what you sort of make of governors coming from military backgrounds.
That they obviously have the gravitas and they have the understanding of public service and those sorts of things, so that does make them well suited. They're also very good at standing up straight and saluting and all those sorts of things, which is helpful from a representational point of view. They're probably, less au fait with the constitutional stuff, but it's hard to know whether that's a good thing or a bad thing. So if you are legally trained and you do have your own views, the real risk is you sit there looking at every single piece of legislation and thinking, that doesn't look right. And that can be problematic as well. The real question is, to what extent, if you were a governor and you're concerned about something, to what extent do you actually have an ability to influence and persuade? So let me give you a little example, and that was, if you read Malcolm Turnbull's autobiography, he talks about during the crisis, the Section 44 crisis, where they kept losing politicians right, left and centre, and they dropped into minority government. And apparently the Governor-General just said to him one day, "And don't bother coming asking me for a prorogation because you won't get one." And so Turnbull didn't. He got warned off. But the thing was, he took the Governor-General seriously. He was Peter Cosgrove. He's a general. You weren't going to sort of, dispute it with him, really, were you? So they can, some more softly and gently than others, actually push back, and they occasionally do.
Thank you, Anne. The Governor is the representative of the head of state. And if the Governor's not in the state of New South Wales, then the Lieutenant Governor. And then if not the Lieutenant Governor, then an Administrator. What changes when the actual head of state is in New South Wales?
Okay. It's Section 7 of the Australia Acts does allow the monarch, when they are in the state, to fulfil some functions. Otherwise, all of the monarch's functions are transferred to the governor, except for the appointment and removal of the governor. But other kinds of functions that the head of state would otherwise have the power to do can be exercised when they're in the state. And that includes, for example, giving royal assent to a bill, because I think it's Section 8 something or other of the Constitution actually has a provision in there, the one that deals with royal assent, and it says at the bottom of it, and by the way, this doesn't stop the monarch from giving royal assent if they happen to be in the state. At the Commonwealth level, they actually have legislation about that, and that's the Royal Powers Act, and that says that if the monarch is in the country, then any power conferred on the Governor-General by statute, and that's important, it doesn't change the Constitution, so these are not constitutional powers. If powers have been conferred on the Governor-General by statute, then those powers can be exercised by the monarch when they're in the jurisdiction. So that's done at the Commonwealth level. At the state level, I don't recollect that we have a particular act that does that, but there's a bit of flexibility in terms of, they can normally open Parliament and hold an Executive Council meeting or whatever, but mainly it's sort of ceremonial in nature.
Excellent. So I will just quickly go to an online question before coming back to the room for our last question. So the online question is, what would happen if Australia were to become a republic? Would we have a Commonwealth president as well as presidents in each state? Okay. So, good question. It depends on the model that you choose. So that's the first answer. But you would, presuming you would like to keep the same kind of system and not really disrupt it, then you would have someone at the state level as well as someone at the Commonwealth level. You don't have to call them a president. You could just call them a head of state or whatever. You could keep calling them a governor in the state. Back in 1999, the Republic referendum did not alter the relationship between each of the states and the Crown. So we were going to have a bizarre system where we had a republic at the Commonwealth level, but each of the state governors were still representatives of the monarch.
And basically what was going to happen was it was going to be left to each state to sort itself out. And so some states would have required a separate referendum to change their constitution, so you need a state referendum as well. There's a debate about New South Wales and whether or not you need one. I was the Republic woman at the time, and in New South Wales we did decide it was probably, given the ambiguity, so the Crown is not, the monarch is not entrenched in particular provisions in the Constitution, but there are provisions that are entrenched in the Constitution that refer to royal assent. And so does the fact that it mentions royal assent in the provision mean that you would be changing the meaning of that provision without a referendum if you got rid of the royal part? Probably need a referendum. So some of the states would have had to do that. The general theory was, if the Australian people voted for a republic in such numbers, and you remember you'd have to have a majority in at least 4 states, then it would be likely that the governments in those states would also proceed toward a republic. And it was also considered likely at the time that the Queen would not be terribly keen on remaining as Queen of Tasmania or Queen of Western Australia, and that she'd probably give them the boot and say, hurry up, get on with it. Because that's how they got rid of the imperial honours in Australia. There were some states that were hanging on to imperial honours, and it was actually Buckingham Palace that said, look, sorry, this is ridiculous. It's gone at the federal level, time to let go. So that was an assumption. What would happen next time round? Nobody knows. All right, there's another question over there.
And parking the fact that the role usually comes with fabulous house, garden, vehicles, hats, would being a governor be an interesting role for somebody like an esteemed constitutional law academic?
I have to say, if you're asking, I would be very badly suited to the role. Well, on the one hand, I'd really like the constitutional side of it. 90% of the role of a governor is the community representational one, and you have to have that kind of outgoing, bubbly personality that you're out there talking to people all the time. And I'm an introvert, so I would be hopeless at it. As I say, I could happily do all the constitutional side of it, and if they ever wanted to split the job and say, hey, you can sit in your office and do the constitutional stuff and we'll have someone else going out doing every one of the afternoon teas and lunches and whatever, then yay, I'd be up for it. But the reality is, knowing my personality type, I would be bad at the job and I would not take a job I would be bad at. So there you go.
Just to take that point seriously, if we split the role and created a kind of ambassador of New South Wales and then reserve the constitutional role to the governor, would splitting the role diminish some of the constitutional authority of the governor?
Yeah, I don't know. That's an interesting question. I've never seriously thought about splitting the role at all until the point was raised.
I have, so...
Oh, okay. Yeah, it's an interesting question. I don't know. I mean, obviously, the community aspect of the role is really important, and there's a really good educational aspect of it as well. I mean, so, for example, I was over at Government House the other day, and they'd set up the room for all the, school captains from all the schools come, and they, get a talk from the governor, and they learn about the system of government and all those sorts of things. That's fantastic. And I think that, the educational aspect of it does require that it comes from the person who's doing the constitutional aspect of it as well. You just need to find people who have both aspects in their personality, have the knowledge side and the gravitas side, but also have the community outgoingness. So, Margaret Beasley's perfect for that because she can do both. But admittedly, it is hard to find people who are suited at that. There was an unfortunate appointment of a Governor-General in Canada who really didn't understand what the job was like and didn't like people looking at her. That is not a job for a person who doesn't want people looking at them, It all ended in tears. So the one thing I would say is that anyone who ever contemplates signing up for that job really, really needs to understand the demands of it. I mean, you can look at all the rubbish in the newspaper recently about the Governor-General and the salary and all the carry-on of, why do they need that much money and the whatever. But it is a hard job. It has so many aspects to it. It's incredibly physically demanding. So it's not an easy sinecure, put it that way.